Creating a last will and testament in Indiana without seeking legal advice may seem intimidating at first. However, most wills can often be made by oneself if provided the right guidance, effectively avoiding the expense of a lawyer. In this video, we'll discuss the importance of wills and what happens when one isn't made, what is included in wills, legal requirements in Indiana, and how and where to create an official will. Let's begin. Wills and their importance. A last will and testament, also simply known as a will, is a crucial document used to convey how an individual wishes to distribute their property among family, friends, and other beneficiaries after their death. It's recommended that all adults have a will in place, especially those who are in the later stages of life. Now, what occurs if no will is left in Indiana? A person who passes away without a will loses control of who inherits their property. The state of Indiana and its succession laws will dictate how the deceased property is managed. Typically, the assets pass to the deceased spouse and/or any children. When clear instructions are not left, disputes may arise between loved ones regarding who is the rightful heir to certain property, which may lead to drawn-out court trials. One can avoid any ambiguity by making a clear will document, and often without an expensive attorney required. A person of sound mind can draft his or her will in Indiana with the following essential information: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witness signatures. And finally, let's briefly review some legal requirements in Indiana. Last will and testaments in Indiana must be signed by the person to whom the will belongs, known as the testator, in the presence of 2 or more trusted and competent witnesses. Though optional, it is recommended for both witnesses to be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. Once created and signed, the document will be legally binding. Multiple copies can be made and given to trusted individuals for safekeeping. We're eForms, the biggest database of legal documents. We have created extensive last will and testament templates for Indiana that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions. Click on the link below to begin creating your will. And don't forget to like and subscribe for more daily videos.